The Law Reform Fraudulent Transactions Act. Let me say at this point, I am not an attorney at law. Let's read through the act. This is dated 22nd of February, 1968. This act may be cited as the Law Reform Fraudulent Transactions Act, at Section 1, short title. Section 2. In this act, court means in relation to any matter the court or arbitrator by or before whom the matter falls to be determined. That's the interpretation. Section 3. Adjustment of rights and liability of parties to frustrated contracts. Subsection 1. Where a contract governed by the law of Jamaica has become impossible or performance or has been impossible of performance or has been otherwise frustrated, and the parties thereto have for that reason been discharged from their further performance of the contract, the following provisions of this section shall, subject to the provisions of Section 4, have effect in relation thereto. So if you have a contract with somebody else and, as it says, the contract becomes impossible of performance, it's impossible for you to continue performing under that contract or otherwise frustrated, then Section 4, the provisions of Section 4 have effect on that contract. Alright. Subsection 2 of Section 3. All sums paid or payable to any party in performance of the contract before the time when the parties were so discharged, in this act refers to as the time of discharge, shall, in the case of sums so paid, be recoverable from him as money received by him for the use of the party by whom the sums were paid, and in the case of sums so payable cease to be so payable. So all money that you were paid or would be payable in pursuance of the contract before the time when the parties were so discharged. So basically, if they were supposed to pay you, but you have not done the work due to being frustrated for some reason or another, you're not able to continue performing the work, the sums by the parties by whom the sums were paid, in the case of sums so payable, cease to be so payable. So basically, you're not obligated to be paid for work you have not yet done. Alright. Provided that if the party to whom the sums were so paid or payable incurred expenses before the time of discharge in or for the purposes of the performance of the contract, the court may, if it considered it just to do so, having regard to all the circumstances of the case, allow him to retain or, as in the case may be, recover the whole or any part of the sums so paid or payable not being an amount in excess of the expenses so incurred. So if you spent money in order to perform the contract, but you're not able to perform it anymore, the money that you spent in preparing to fulfill the contract, the court can award you that money. That seems to be what it is saying. So that's section 3, subsection 2. Subsection 3, where any party to the contract has, by reason of anything done by any other party thereto in, or for the purpose of the performance of the contract, obtained a valuable benefit other than a payment of money, to which subsection 2 applies, before the time of discharge, there shall be recoverable from him by the said other party such sum, if any, not exceeding the value of the said benefit to the party obtaining it, as the court considers just, having regard to all circumstances of the case, and in particular, a. the amount of any expenses incurred before the time of discharge by the benefited party in or for the purposes of the performance of the contract, including any sums paid or payable by him to any other party in pursuance of the contract, and retained by or recoverable by that party under subsection 2, and b. the effect in relation to the said benefit of the circumstances giving rise to the frustration of the contract. Alright, subsection 4. In estimating, for the purposes of the foregoing provisions of this section, the amount of any expenses incurred by any party to the contract, the court may, without prejudice to the generality of the said provisions, include such sums as appears to be reasonable in respect of overhead expenses, and in respect of any work or services performed personally by the said party. So, overhead expenses would be those expenses that you have to pay whether you did any work, such as rent or utilities. Now, in estimating, for the purpose of the foregoing provisions, the provisions before of this section, estimating the amount of money to be paid to you as a contractor, the amount of any expenses incurred by any party to the contract, that would be such as you, the court may, without prejudice to the generality of the said provisions, include such sums as appears to be reasonable. So, your bills, you can sue to recover your bills. 5, subsection 5 of section 3, in considering whether any sum ought to be recovered or retained under the foregoing provisions of this section by any party to the contract, the court shall not take into account any sums which have, by reason of the circumstances giving rise to the frustration of the contract, become payable to that party under any contract of insurance, unless there was an obligation to insure imposed by an express term of the frustrated contract, or by or under any enactment. So in considering whether someone should be paid, any sum ought to be recovered or retained under the previous provisions of this section by any party. So in considering whether you should get any money, the court will not consider sums which have, by reason of the circumstances giving rise to the frustration of the contract, become payable to that party, to you, under any contract of insurance. So if you had paid, it seemed like if you had already spent money, incurred expenses, right? It says by reason of the circumstances giving rise to the frustration of the contract, become payable to that party. So money that becomes payable to you. So in that case, the court would not consider that money that became payable to you unless you were obligated to be paid. There was an obligation to insure imposed by an express term of the frustrated contract. So it would have had to be in the contract before. If it was not in the contract that you were to get that money, then you wouldn't get that money. All right? It seemed like that is what this is saying. Where any person has assumed obligations under the contract in consideration of the conferring of a benefit by any other party to the contract upon any other person, whether a party to the contract or not, the court may, if in all the circumstances of the case it considers it just to do so, to treat for the purposes of subsection 3 any benefit so conferred as a benefit obtained by the person who has assumed the obligations as aforesaid. Section 4, provisions as to application of this act. Subsection 1, this act shall apply to contracts whether made before or after 23rd of February 1968, way back, as respect which the time of discharge is on or after the said date, but not to contracts as respects which time of discharge is before that said date. Subsection 2, this act shall apply to contracts to which the Crown is a part in like manner as to contract between subjects. So whether it is a government contract or a private sector contract, this act applies. Subsection 3, where any contract to which this act applies contains any provisions which, upon the true consideration of the contract, is intended to have effect in the event of circumstances arising which operate or would, but for the said provisions operate, to frustrate the contract, or is intended to have effect whether such circumstances arise or not. the court shall give effect to the said provision, and shall only give effect to Section 3 to such extent, if any, as appears to the court to be consistent with the said provision. Where it appears to the court that a part of any contract to which this act applies can properly be served for the remainder of the contract, being a part wholly performed before the time of discharge, or so performed except for the payment in respect to that part of the contract of some which are or can be ascertained under the contract, the court shall treat that part of the contract as if it were a separate contract, or has not been frustrated, and shall treat Section 3 as only applicable to the remainder of that contract. Subsection 5. This act shall apply A. to any charter party except a time charter party or a charter party by way of demise, or to any contract other than a charter party of the carriage of goods by sea, or, alright, so a charter party, based on information I found online, is a contract between a person who is the charterer and a ship owner for the hire of a vessel for the carriage of cargo or passengers. So that's a charter party. So it will not apply to any charter party except a time charter party or a charter party by way of demise, or to any contract other than a charter party for the carriage of goods by sea. B. To any contract of insurance save as is provided by subsection 5 of Section 3, or C. To any contract to which Section 8 of the Sale of Goods Act applies, or to any other contract for the sale or for the sale and delivery of specific goods where the contract is frustrated by reason of the fact that the goods have perished. So read that part again. To any contract which Section 8 of the Sales of Goods Act applies, or to any other contract for the sale or for the sale and delivery of specified goods where the contract is frustrated by way of the fact that the goods have perished. So if the goods are no longer good, or they have been destroyed, then this contract applies. Here, if the ship sinks, so it's charter party by way of demise, or there is some other damage to the goods being transported by the ship, then this act applies. You're obligated to get money that you are owed. That's what it seems. It does not apply to any contract of insurance, save as is provided in subsection 5. So, if it is written in the contract that you should be paid a certain amount of money, if the contract can no longer be carried out, then you should get that money owed to you. So you see the way that these legal documents are written. seems to me that they say things that are clear, easy to understand, but is written in a way to frustrate someone reading it. Very, very long sentences that could be broken up into shorter sentences. Alright? That's how these documents are written, and written long time ago. Alright, so that's the Law Reform Fraudulent Transactions Act.